This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. This is a case where Liebowitz has lost to the attorneys at Booth Sweet, Jason Sweet and Dan Booth. This is a case called Glenn Craig versus PopMatters, and I'll let the judge tell the story. This is in the Northern District of Illinois, Eastern Division. This is Judge Ronald Guzman. Defendant's motion for an award of attorney's fees is granted in part and denied in part. The court orders plaintiff Glenn Craig to pay the prevailing party, defendant PopMatters, attorney's fees in the amount of $24,000. On defendant's bill of costs, defendant is awarded $150, etc. On October 19th, 2019, plaintiff Glenn Craig voluntarily dismissed this action. Before the court is defendant's bill of costs as well as its motion for an award of attorney's fees under 17 U.S.C. 505 or 28 U.S.C. 1927. On January 8th, 2020, the court entered an order striking plaintiff's memorandum in opposition to defendant's motion because it was excessively long without plaintiff having sought leave of court, and 2, plaintiff's counsel had failed to comply with a previous order directing him to file an application to appear pro hoc vice. Hey, wait a second, Tack. Was this the case where Liebowitz got denied pro hoc vice into Illinois? We'll have to look that up.
There was a lot of cases. Anything in Northern District of Illinois, he did not properly apply for pro hoc vice in a timely way.
The court took defendant's bill of costs and fee motion under advisement and indicated that a ruling would be issued without a response from plaintiff. Craig alleged in his complaint that defendant PopMatters Media infringed his copyright by impermissibly displaying on its website Craig's photograph depicting jazz musician Miles Davis. This case is a refiling of an action that Craig first filed in the Southern District of Illinois. After PopMatters raised objections to personal jurisdiction and venue there, Craig voluntarily dismissed that action. He refiled the claim in this court August 19th, 2019. On October 18th, 2019, PopMatters filed a motion for entry of an order requiring Craig to pay the attorney's fees and costs PopMatters incurred in the Southern District action and to stay this case until those costs were paid. The following day, Craig filed a notice of dismissal of this action pursuant to Federal Rule of Civil Procedure 41. Okay, so something about that requirement to pay fees motivated them to dismiss the new case. The dismissal states that it is without prejudice, but the declaration does not make it so. The privilege of dismissing a federal suit without prejudice to refiling may be used only once. Craig used that privilege when he dismissed the Southern District case, so his dismissal of that case operated as a with prejudice dismissal, an adjudication on the merits. See Federal Rule of Civil Procedure 41 if the plaintiff previously dismissed any federal action based on or including the same claim, a notice of dismissal operates as an adjudication on the merits. PopMatters seeks attorney's fees under the Copyright Act, which authorizes the court to award reasonable attorney's fees to the prevailing party as part of the costs. There is no question that a dismissal with prejudice makes the defendant the prevailing party for purposes of an award of attorney's fees. This is no less true when a case is dismissed because the plaintiff threw in the towel, that is, where the dismissal is on the plaintiff's own motion. The prevailing party in copyright litigation is presumptively entitled to an award of attorney's fees under Section 505. Plaintiff's memorandum in opposition to the defendant's motion was stricken, so plaintiff has failed to rebut this presumption, and the court sees no reason not to award defendant its reasonable attorney's fees. The court considers the totality of the circumstances, including the frivolousness of the claims, the motivation of the parties, objective unreasonableness, and the need in particular circumstances to advance considerations of compensation and deterrence. The circumstances here favor an award of attorney's fees. Defendant has presented persuasive evidence and argument that it has substantial defenses to plaintiff's copyright claim, that defendant's use was licensed, and that plaintiff's photograph was a work made for hire, and that plaintiff's motivation in filing the action was to obtain proceeds from a settlement rather than to protect against infringing use of his copyright. That sounds an awful lot like a lot of Liebowitz cases, huh? We've seen that before. See generally the Design Basics versus Lexington Homes case. You remember that one? We did a video on that. That was the floor plan case, the home design case. In recent years, opportunistic holders of copyrights, patents, and other intellectual property have developed unsavory reputations for trolling, bringing strategic infringement claims of dubious merit in the hope of arranging prompt settlements with defendants who would prefer to pay modest or nuisance settlements rather than be tied up in expensive litigation. Plaintiff's dismissal of this case appears to have been an effort to avoid paying fees for the first action and/or to avoid a decision on the merits. PopMatters seeks a total fee award of nearly $40,000 for 90.5 hours of work by its primary counsel, Dan Booth, at an hourly rate of $425 an hour, and 4.4 hours of work by its local counsel, Scott Stuckel, at an hourly rate of $250 an hour, as well as travel expenses. Reasonable attorney's fees are generally calculated by the lodestar method, which requires the court to multiply the number of hours reasonably expended on the matter by a reasonable hourly rate. The number of hours reasonably expended on a matter does not include those that are excessive, redundant, or otherwise unnecessary. If at any time entry is too vague to allow an assessment of reasonableness, the court may disregard it. The court will begin with Stuckel's time entries. Stuckel spent minimum time on this matter in his role as local counsel, and his billing records demonstrate that the time he spent was reasonable and necessary. Fees, therefore, would be awarded defendant for his 4.4 hours of work and travel expenses for a court appearance. Now, didn't we just see last year there was I forget which case it was. There was a copyright case in March of last year. The Supreme Court said that you don't get travel expenses as part of fee shifting under 17 U.S.C. 505. Maybe 1927, but I don't know. I'm not gonna challenge $33 here, but there are some problems, however, with Booth's time entries. The court indicated in its order of January 8th, 2020, that the time Booth spent on defendant's motion to strike plaintiff's memorandum in opposition to defendant's motion for attorney's fees is not compensable because the motion was unnecessary. Booth also includes several time entries totaling 3.2 hours for clerical tasks, such as preparing and compiling exhibits, preparing notices of motion, filing documents, and contacting the courtroom deputy, which the court will disallow. Moreover, certain time entries totaling 2.9 hours are described too vaguely for the court to assess their reasonableness. Thus, the court will subtract nearly 10 hours from the amount sought with respect to Booth's time entries, which leaves a total of 81 hours. These remaining hours reflect more substantive tasks, but there are also problems here. The number of hours Booth devoted to communicating via email with his client and local counsel is excessive. It strikes the court that much of this communication could have been done more expeditiously via telephone and less often. And most significantly, the time Booth spent researching and drafting defendants' filings was excessive. For this type of work, Booth billed over 20 hours preparing defendant's motion for entry of an order requiring plaintiff to pay the attorney's fees defendant incurred in the Southern District action, 6.3 hours on an 8-page single-spaced letter to opposing counsel in an attempt to resolve fee disputes under Local Rule 54.3, over 5 hours on what should have been a simple motion seeking instructions from the court under 54.3, and over 20 hours on defendant's reply to plaintiff's response to defendant's fee motion. This time was excessive. Defendant's filings and declarations in support of its filings were needlessly lengthy. They recited and reiterated in inordinate detail the facts behind the creation of plaintiff's photograph, the procedural history of the case, and plaintiff's counsel's history of copyright litigation. For example, a single footnote in defendant's reply brief on its fee motion contained citations to 15 federal court decisions supporting its argument that plaintiff's counsel's firm's rare litigated victories in copyright cases are far overshadowed by its many losses on a wide range of substantive grounds. So he's pointing out Leibowitz's other cases. A point of no utility to the court in deciding the fee motion. Unfortunately, the fee matter became the tail that wagged the dog. In the court's view, the legal work undertaken by Booth in this case was very brief and should reasonably have taken 2/3 of the hours he billed for it. The court therefore reduces by 1/3 the remaining 91 hours, which results in 54 hours of compensable work attributable to Booth. The next task is to determine whether counsel's hourly rates are reasonable. The Seventh Circuit has held that in a copyright case, case, the best value of a lawyer's services is what the client agrees to pay him. Booth submits a declaration in which he states that he charged PopMatters, and PopMatters agreed to pay him his standard rate of $425 per hour for his services in this action. Furthermore, Booth submits evidence that in 2013, one of his clients was awarded fees at an hourly rate of $409 an hour, which was Booth's standard rate at the time, in an action in the Southern District of Illinois. And 2, survey evidence that this hourly rate is less than the average rate charged by partner-level attorneys in intellectual property matters in the Chicago area. Local counsel Stuckel submits a similar declaration about his $250 per hour, and he submits evidence that the Cook County Circuit Court awarded one of his clients his fees at $250, and survey evidence that his hourly rate is below what is charged by private law firm attorneys in Chicago with similar years of experience. Accordingly, the court finds that defendant's lawyers reasonably spent 58.3 hours defending this suit, pursuing fees at the reasonable hourly rates of $425 and $250. The court awards defendant $24,000 plus travel expenses of $32.95. In light of this ruling, the court need not reach defendant's argument in the alternative that a fee award is proper under 1927. So the court did award the travel fees under 17 U.S.C. 505, which I think is actually incorrect. But it's $32.95. If it was $3,300, maybe I'd be opposing that. Maybe Liebowitz would be filing some kind of, or Leibowitz's client would be filing something as far as like a motion for reconsideration and pointing out the error of law. But maybe I got it wrong too. Maybe my interpretation of that case is wrong. But I'm pretty sure I got that one right. As the prevailing party, defendant filed a bill of costs seeking reimbursement of the pro hoc vice fees, which is a taxable cost. Therefore, the court will also award the pro hoc vice fees of $150. And that's Ronald Guzman. And so that's what happened with another Liebowitz case. They filed in the wrong district, then they filed in the right district, then they got a request for fees from the wrong district case, then they dismissed voluntarily. That got converted to a with prejudice dismissal, and then Booth Suite got $24,000 of their fees paid by a Liebowitz plaintiff. Now, who actually pays that money? I'm not sure. It's awarded to the defendant from the plaintiff. And so it's the agreement of the parties and what they work out. So maybe Liebowitz talks to his client and figures out who's going to pay the $24,000. Maybe Booth Suite talks to their client and has something in their contract about Booth Suite collecting the $24,000 or not. So sometimes it's the actual prevailing party, like the party that gets the money because they've already paid it to their attorney. Sometimes the attorney hasn't collected the money yet, and so they'll get the money instead of the client getting it. So that's all going to be handled privately, and we're not going to see anything more about that unless there becomes like some contract dispute or something, which probably doesn't make it to federal court, probably doesn't make it onto our radar. So let us know what you think of that. That is another weirdly handled Liebowitz case, dare I say poorly handled Liebowitz case. I don't know at this point which ones are poorly handled or just weirdly handled or just accidents or whatever, but they happen at a much higher rate than I would like to see from a practicing attorney. Let's just put it this way. I would be appalled at myself if I made this many mistakes. I'm appalled at even the slightest mistake that I make, so it's weird to see this being a normal operation of business for an attorney. Anyway, let us know what you think. So that's our show, everyone. I'm Leonard French, your favorite copyright attorney. Thank you to Brandon and Tack for joining me for this morning's show. Thank you for watching this production of Lawful Masses, your favorite legal news and education channel. Please subscribe to our YouTube channel. Please support us on patreon.com/ljfrench and sponsus.com/law. This channel would not exist without your support. We also have YouTube memberships available and Floatplane memberships available, and we're going to be doing more and more exclusive content for our supporters as I get better and better at it. Please send us your suggestions for what you'd like to see as exclusive content, and we'll figure out what to do for you as well. Thank you to our $50 plus supporters in the month of April. Thank you to Wes Delj, Video Quarantined, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Michael Pearce, Jan Negrey, Daniel Perez, Aspernari, Joe Tyson, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Nicely Done Defense, Mullen PC, Sean McNamara, Josh Baker, Ugly Grill, Gregory, Shielo T, Michael Moore, and Beastman. I appreciate you all. All the $5 plus supporters are scrolling on the LED panel over here. You'll all appear in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. Have a good week. Have a good, hopefully, final weeks of shelter in place and quarantine and all that. And I'll try to keep you up in the legal news and education with our channel here. I'll see you in the next one. Love you all. Bye.